I'm just going to wait for you guys to tune in. How is everyone doing? Good morning, Facebook. Good morning, Instagram. Good morning, YouTube. If this is your first time joining, welcome. Good morning. Nice to have you here. I'm going to introduce myself real quick, but before that, let me just make sure that my Facebook is showing. Okay, so it's showing. Okay, so for those of you who don't know me, my name is I485 RF. I'm an immigration attorney and I represent clients all over the United States with their immigration matters. I handle humanitarian-based cases, complex family immigration, regular immigration, family immigration cases. So we do, of course, marriage cases, VAWA cases, U visas, T visas. Oh yeah, let me not get distracted with the questions right now. Appeals, removal of conditions, removals based on waivers, naturalization, and all the other fun stuff. If you want to schedule a consultation, you can call 678-325-1037 or 407-995-6567. You can also send a WhatsApp to 404-333-8751. Okay. These numbers are also in our profile pages. So if you're on Instagram, it's right there in the profile. Same thing on Facebook, same thing on YouTube, TikTok. You can find us everywhere. So I want to jump right on in. Someone says you look radiant. Thank you so much. This is probably all going to change next week when my kids start back with school, because since my kids are out of school, I've been able to get an additional hour and a half of sleep. And let me tell you, it makes a huge difference because, when my kids are in school, my kids go to school an hour away from where we live. So we usually would wake up at 5:30 a.m. to get them, together and go there. So that would all change next week, but hopefully I can still go to bed on time. So today I want to talk about, financial affidavit of supports, and just some of what the trends we're seeing right now, and especially for those of you who are filing applications that require it, such as like a marriage-based case or a family-based case. So first, let me talk about cases that we handle that don't need financial affidavit of support. So this doesn't apply to you. So if you're a VAWA applicant, this does not apply to you because you're exempt from a financial affidavit of support. If you're a widower, this does not apply to you. If you're filing T or U visas, this does not apply to you because you can't even file a 485 simultaneously. So I'm specifically talking about people who file for a marriage-based application, or they're filing for a green card for, either a parent or a child or a sibling, and they're doing the 485 or they're doing the consular processing where an I-864 is needed. First of all, that's what the form is called. In the past, typically you have to basically show that you meet 125% of the poverty guidelines to be based on your family size to be eligible to sponsor someone. So what does that mean? So typically, each person that applies is going to have a different number of what their income needs to be. So for example, if you're a family of two, the safest place would be to have, i.e., you're showing that you're making more than $27,000 annually. If you're a family of three, you want to show you're making more than $33,000 annually, and the number just goes up and goes up like that. How they determine family sizes is they're going to look at you and whoever you're sponsoring. If it's not your spouse, they're going to look, do you have a spouse? That spouse is going to be added in as an additional person. If you have children under 18, whether or not those children live with you, you as the U.S. citizen petitioner, those will be counted towards your family size. And that's what you make the determination as to which income bracket do you fall under. So in the past, when you're filing a financial affidavit of support, even if your previous year's income didn't meet the requirement, if you can show that your current income meets it with an employment letter and maybe pay stubs, that typically would be enough. So let me use a simple example. Let's say like you're a family of two, and in the past, maybe you made $23,000 for your tax year of 2024. But right now you make $40,000. And you have your job offer showing you make $40,000, and you've got some pay stubs. What we're seeing, and this is very recent that we're seeing this, this year since the new administration, they're wanting more. They're going to basically want you to have a joint sponsor. So basically, they're no longer looking at what your current income is. The focus seems to be on what your most recent taxes say. So, and when I say most recent taxes, it would be for the tax year before the filing or whatever the year is. So like, for instance, now we're in August of 2025. So your most recent filing that they want to see is 2024. Okay. If let's say we get to 2026 and you apply in January, for example, January 2026, it's going to still be 2024 that they need. It only changes to 2025 after the tax deadline, which is April 15th. So after the tax deadline, then it would be the 2025 taxes next year. So it's really important that if you're filing as a sponsor, or if someone is filing for you and they're teetering on the edge, that you have a joint sponsor. The joint sponsor should be a U.S. citizen and a 10-year green card, or a 10-year green card holder. If that joint sponsor is married, understand that they are going, and let's say they file taxes and they file taxes together, like they and their spouses file taxes together, you want to make sure that the joint sponsor, we have a way to vet or verify that joint sponsor's income apart from their spouse. So they're going to want to see that joint sponsor's own W-2. So for example, if let's say like the husband and wife that are doing the joint, like the wife is or the husband is doing a joint sponsor, and the joint sponsor, maybe their taxes show that they made $100,000 that year, USCIS is going to want the demarcation between what was the husband's and what was the wife's. So let's say if the wife that is sponsoring you was making maybe like $22,000, even though she has a family, like a household income of $100,000, they're going to say she's not eligible because she made $22,000, unless her spouse is willing to come along, as a supplemental sponsor on the I-864A form. Then you can do it that way. So I'm saying this because we're definitely seeing that happen. And, I try to educate you guys as we see things change. There's never any official announcement that they're going to start changing how they're reviewing it. But we're definitely seeing RFEs now and saying, no, we want a joint sponsor. Even if you make that income, we don't see it in your taxes. So taxes king. Sometimes people ask me, my U.S. citizen spouse has not filed taxes. How does this impact my application or filing? It impacts it. So if they've not filed taxes, then you can't even move over to a joint sponsor. They must file taxes before they can allow a joint sponsor in there. Like, they want to know they file taxes. So make sure that your significant others that are filing for you are filing for taxes. So that's what I wanted to talk about, the A64. Let me go ahead and take questions. Someone is asking, I have a permanent 10-year green card. Is it safe to travel? The answer is going to be, it depends. As long as you don't have any criminal record and you don't have any on closed or any open removal procedures that are pending, you're safe to travel. If you do have any arrests, definitely speak with your lawyer and find out whether it's a deportable offense, whether it's something that they can hold you back, because we are definitely seeing people with criminal records, even if it was 15 whatever years ago, being detained. So you definitely want to, when I say we are, thankfully it's not any of my clients, but I definitely know from very reputable attorneys whose clients have been in that situation where, on a normal basis, they reported all this arrests and the history to immigration and got their green cards. But then when they came back into the country, like for things that happened like 14, 15 years ago, and then when they came back with an issue. So honestly, like if you have a criminal record, you want to first of all speak with a lawyer, because you want to find out what your record is. Is it a deportable offense? Is it something that could be potentially an issue. And then if it's not a deportable offense and it's not a crime of moral turpitude, your best bet is to go get your citizenship. So if you're eligible for citizenship, this is not the time to dilly-dally and waste your time. Go become a citizen, because really, even being a citizen now, you know, like with all the denaturalization things that they're, you know, potentially trying to do, but still, you're better off becoming a citizen, because that's probably the most secure place. Don't wait 10 years, 15 years on your green card to expire. Just follow the process. You know, if your green card allows you to become a U.S. citizen in 5 years, apply 4 years, 9 months from that time. If your green card allows you to be a U.S. citizen in 3 years, apply 2 years and 9 months from then. So that's the answer, MD Arm. I wouldn't be able to tell you because I don't know your history. But if that's what it is, then don't. And then if you don't have any, then you're fine to travel. Okay, so let me see what other questions you guys have. Hi, SunnySin72, welcome. How long are receipts for VAWA taking now? They are still taking a long time. We are definitely seeing 90 days to 100 days for the receipts on anything basically that's filed that doesn't require a filing fee. My daughter is driving me crazy. I can hear her screaming in the background. I don't know if you guys can hear her as well. This is the problem with working from home. There's such a distraction. But anyway, as I was saying, you know, so we're seeing about 90 days. So if you filed for VAWA, you know, I know it's annoying and it's frustrating. It's also frustrating for us. And, you know, for us, a lot of us lawyers, we are on the receiving end, you know, of USCIS's delay. And, you know, it's frustrating for us because we're human beings as well. And, you know, you can't imagine that we're dealing with our clients' misdirected rage. We're dealing with USCIS's own internal issues with immigrants. So we're the middleman that takes all. Basically, we're like the shock absorbers. We're supposed to take it all. You know, so on one hand, we're like, get these people their stuff. And the other hand, we're like, listen, it's not our fault. Like, this is what's happening. So if it's been more than 90 days, though, you know, an inquiry can be done to try to get it. Like what we're trying to do now is anyone that we see that's been more than 90 days, we've been sending inquiries saying, you know, what's going on. And knock on wood, we've seen some movement, you know, since we started doing that religiously with them getting those receipts. So hopefully you get yours really soon. Oyinko says, good morning to the best attorney. He gets, hey, Oyinko, how are you? Okay. Okay. Can a conditional permanent resident be eligible to file an I-130 petition for their children? They don't need to be an LPR first. Yes, a conditional resident can file for their children. They don't need to be an LPR first, but your removal of condition has to happen for them to finish their process. How long does it take to approve an I-130 for immediate family? Timeline varies. It could be anywhere from 6 months to 13 months if it is for an immediate family, unless there's something that might be delaying your application, like an RFE or NOID, but most people are going to fall within that window. Esther says, good morning, attorney. What's the trend you've seen of how many years it's taken for VAWAs to be approved? Right now, we're seeing about 3 years, 3.5 years is what we're seeing for VAWA cases to be approved. And this is not including the adjustment of status. We're seeing about 3 years to 3.5 years for VAWA cases to be approved. And then after that, two things could happen. They could either approve your green card without an interview. They could request an interview. We're definitely, I would say this month, we've definitely seen quite a few, which I was actually surprised by, getting approved without an interview. But we've also seen many going to an interview. So as far as the interview after your VAWA approval to get your green card, I'd say we're seeing about 50-50 with that. Okay, let's see what else we have in terms of questions. Jumi, hi, how are you? Says my best attorney in Atlanta, Georgia. Thank you so much. I have 60 months. I have 60 months applied for VAWA. Okay, you mean you applied for VAWA 60 months ago? Is that what you're trying to say? I got my social security number, my work permit, but no answer for the VAWA application. Is that normal? Girl, you're just like, you're literally just scratching the surface. If you only just applied, like, You literally have years to go. 16 months is not a long time for a VAWA case. So if you've got your work permit and your social security number, you're in a normal process. From a timeline perspective, when you put in your VAWA, what typically happens is after you've received your receipt, if you meet the requirements to get a prima facie determination letter, usually it comes in like 3 to 5 months, or unless they're sending you an RFE because you don't meet the requirements. And then after that, you get your work and travel permit. I would say we're seeing about 6 months to the dot for most people right now. 6 to 10 months is kind of like the timeline that's normal. And after that, you're just going to be in a waiting period until they're ready to review your case, which usually will take about 2.5 to 3 years. When they review your case, at that time, they can decide whether they're going to approve you or whether they're going to send you a request for evidence, or whether they're going to send you a notice of intent to deny. I know sometimes people ask me, what's the difference between a request for evidence or a notice of intent to deny? And also, do they have to send a request for evidence before they send a notice of intent to deny? Not necessarily. So cases where we'll see a notice of intent to deny outright would be, well, first of all, let me talk about the differences. The request for evidence means basically we don't feel that we have enough to make a decision on your case. What else can you provide to us to make a decision on your case? That's what an RFE, a request for evidence, means. A NOID, which is a notice of intent to deny, means that we have enough information and plan to deny your case unless you can disprove us. So an example of where they might skip like an RFE, to give you a NOID, would be, i.e., maybe you filed a previous application where they basically said your case was a sham marriage, like your previous marriage was a sham marriage, or that you didn't have a qualifying divorce from your previous spouse. They will just automatically go directly to like the NOID if they wanted to, saying, prove to us that that previous marriage was real before we make a decision on this case. So essentially they're saying we have enough for this case, but because of that case, we're not going to approve it unless you can prove to us that that initial marriage was not a sham marriage. So that's like an example. Okay. Let's see what else we have. How long does it take for an I-601 RFE to be approved? I got an RFE for my I485 to file a 601 waiver. Honestly, I can't give you a timeline because there is none, with the RFEs. There's no published timeline for RFEs. I will say that if after 6 months, maybe you haven't heard anything, maybe you can just reach out to USCIS just to find out. But I can't really give you a timeline for that because with RFEs, there's no published timeline necessarily, but after 6 months, you might check in and just, see what's up. Okay. Okay, and I know that some people may or may not have heard about the $15,000 bond. It's not like super relevant to my clientele, but I will share it anyway. Because I'm sure I'm probably going to get some comments asking about it. Where the Department of State basically said yesterday that they are going to be doing what they call a pilot program for those who are coming to the U.S. on a B1, B2 visa. Which means a B1, B2 visa is basically a visiting visa, a tourist visa, a traveling visa, whatever you call it, where basically in order for them to approve a visa for you to come into the United States, if you're coming from certain countries that have a high rate of overstay, you're going to need to pay $15,000. So the price changes. There are like 3 stages to the price. For some people, like children, it would be like $5,000. Some people will be $10,000. Some people will be $15,000. It's a pilot program that they're going to try and do for 12 months. And basically what they're saying is that if you return back to your home country, then they will give you on time, then they will give you back the money. So I guess for those people, it's going to replace the $250 visa integrity fee that they've also stated that they want to do. As far as countries that this is going to apply to, We don't quite know yet. I mean, people have thrown out like certain countries that have a high rate of like visa overstays, like Haiti, Brazil, Colombia, Mexico, Venezuela, Dominican Republic. But those are just speculative, and you guys know how I feel about speculation. I prefer to give you guys the real news once the law has been put in place. But this is something maybe to note for like your family and friends that want to come to the U.S. or applying for visas, that there's a possibility that they might have to, pay this amount of money to come to the U.S. Okay, let me see. I applied for VAWA a year now. I got a prima facie within 6 weeks. I applied for work permit and they denied it in December. I sent the I485 in April because they said I didn't do that. I didn't get a receipt. Wait, so you applied for an I485. So your question is that you applied for an I485 and you haven't gotten a receipt. If that's your question, then you should be reaching out. Remember, like the beginning of the slide, I talked about there's a delay in any cases where there's no filing fee. An I485 that is under VAWA doesn't have a filing fee, so it would fall under that delay. If you count from when you submitted it and you're sure it was delivered, that the 90 days has passed, then you want to definitely reach out and see whether or not they will issue your receipt. You can either send them a letter. If you're working with an attorney, then your attorney can do the direct attorney email. And the next person is asking the same question. So that's your answer. Is that safe if I have no criminal records to go back to America with a green card holder for 6 months? I'm not sure I understand your question. Are you saying that you have a green card and no criminal records and you want to come back to America, or you want to leave America? Like, can you just clarify that for me? Okay, let's see what else I have here. Okay, someone says, I have one question. Go ahead and type your question. I have a 5-year travel and work permit. It's been more than 2 years, no RFE, nothing. What should I do, please? Without knowing your case type, I can't really tell you what to do. My husband had single filing, single on his taxes. Should he amend it? Well, the answer is going to depend on when you got married. If you were married during those times, did you have a social security number, an ITIN? If you didn't have any of those, you kind of have an excuse, as long as you provide something from the accountant showing that, he was not able to, or maybe he could have amended it to like head of household. I generally stray away from like advising on taxes just because I'm not a tax professional. But for a lot of people, if you don't have a social security number and ITIN, your spouses usually can't add you to that, but they can probably under head of household. But that's something that, an accountant usually has to write a letter to support. Like when we have that, we usually ask them for a letter from the accountant confirming that they couldn't add the spouse, just so that we have that, for documentation purposes. I filed for my spouse who resides in Jamaica, but he has a B1, B2 visa. Can he continue to travel to the US while we're waiting for his what do you mean K3? So what did you file for him? Did you file a K3 as opposed to consular processing if it's already like your spouse? Like, I don't know why you filed that K3. But yes, he can continue to travel at a B1, B2 as long as he has it and he doesn't violate his, visits and leaves when he's meant to leave. Will an arrest record for expired driver's license and car insurance stop you from getting citizenship? No, it will not. What are the common RFEs you see for VAWA? This is going to be the last question I take, and then I got to jump off. I would say that the most common RFEs was going to be cohabitation, proof of cohabitation, and proof of good faith marriage. Those are going to be the most common one. I mean, it's quite peculiar with, VAWA cases where, as a victim of abuse, for a lot of people, you don't necessarily have the power and control to have the financial documents that someone who's in a happy marriage will have. So, if you have a spouse that's controlling and has refused to put you on any documents, has refused to file for you, so you don't have a social security number to get in things, they don't want to put you on the lease, they don't want to put you on all of that. The key is being able to explain it in a way that an officer can understand, because that sometimes is part of abuse. And it's really being able to articulate and explain how and what steps that you took to try to get those things to show that you've built a life together, you're building a life together, but you have a spouse who is, I am going to put my daughter on timeout when I get off this call because she is screaming. I don't know what they're screaming about. Anyway, as I was saying, so that's what we see the most of. But I hope you guys have a great week. And if you need to schedule a consultation, don't hesitate to call us, 407-995-6567. You can also call 678-325-1037, or you can send a WhatsApp to 404-333-8751. This information is also in all of our profiles. Have a great day, guys, and I will chat with you all later. Bye.